Hello, I'm Richard Barker,
Carrie March.
and there are our details if anyone wants to scan the QR code or connect with us on LinkedIn. So welcome to the latest in our People Matter series on redundancy processes. And this session is focusing on 5 mistakes to avoid, as you can see there. So this is a re-recording. We presented this a week or so ago, and there were some technical issues, so we're re-recording this to be hosted on the website. In advance of the session that we did receive a number of questions for the session, which focused on collective consultation. So actually, that's quite a handy plug for our next session, which is coming up in September, Thursday, the 21st of September, which is all around collective redundancies, tips and traps. So that's not something we're going to cover in this particular session, but that is something that we covered in detail then. So today's session is going to focus a lot more on individual consultation and mistakes to avoid in respect of any kind of redundancy scenario, not just collective. So in terms of what we're going to cover today, the 5 sort of mistakes we're going to try and talk through about avoiding are: firstly, not consulting with an open mind; secondly, dealing with absent employees; thirdly, discriminatory selection criteria; fourthly, forgetting to focus on the roles; and fifthly and finally, alternative employment. So with that in mind, I'll hand over to Carrie on number 1.
Great, thank you so much. So this is about not consulting with an open mind. So we all know that consulting on redundancy is a key component in being able to show that we've done a fair redundancy process. We've got to consult with an open mind, which means that we should be capable of influence. And where we often see this go wrong in practice will be a couple of key areas. One will be that questions or concerns that are raised by those that have been placed at risk aren't actually responded to. So there's not a clear Q&A trail. The other will be that a sound business reason isn't given. So the company might be able to have avoided the redundancy if they had taken up one of the suggestions that someone had put forward. That's not always going to be possible where there's a real need for an urgent cost saving for a business, and a tribunal would always take that into account. But insofar as it's possible and practicable for a company to do so, it should be making room in its process to be able to go back to people on the points they raise, and that should they have a viable alternative route that might limit the scope of redundancies or reduce them altogether, that it's clear that that has been responded to and considered, and it was capable for the redundancy process to be turned around or minimised based on the comments that have been provided. And the staff are often always going to be the ones that are best placed to come up with those alternatives. So if the business rationale has come sort of at quite a few levels up in management, what we want to be able to show if we're ever in dispute is that whilst the decisions may have been made at a very high level, that those have been fed down and considered by all levels within the team, so that alternatives have been properly considered. So it's important when running the process that you're able to step back and look at your timeline and try and pinpoint at which point you can be persuaded to no longer make redundancies and where you may no longer be capable of being influenced. And if employers have the opportunities to challenge plans or criteria early, then practically you're not going to bottleneck that resistance right near the end when you might need to start issuing your notices. Also, if an employer is going to carry out their scoring before making any communication with those that may be placed at risk, it's going to likely be difficult to persuade employees that consultation began at a point where your proposals to make people redundant were at a formulative stage. But what is always still helpful to remember is that you're not compelled as an employer to adopt the proposal suggested, but you just need to make time for the challenge and show that you've considered and responded back to people on those points. And secondly, if you forget to do so or unable to do so, it may be that it would have made no difference ultimately to the end result, the end redundancy. And so when we're in a tribunal situation, if an employee were to have a successful claim, we would often consider to what degree compensation may be reduced substantially or altogether under what we refer to as the Polkey deduction, on the basis that a correction in the process for consultation would have made no ultimate difference to the result. Now I'll hand over to Richard for number 2.
Thank you, Carrie. So our second mistake to avoid is not consulting with absent employees, either at all or appropriately consulting with them. So by way of a very quick reminder, as I'm sure you know, redundancy is a potentially fair reason for dismissal. That said, like any other dismissal, to avoid a claim for unfair dismissal, a fair process needs to be followed. And when we're looking at redundancy, what we're talking about there is the concept of consultation, whether that's individual consultation or collective consultation, which, as I said, will be covered off in our September session. But there's a real focus on what is the consultation and is it meaningful. So in terms of the logistics of managing that consultation, certainly pre-pandemic, consulting with employees who were at work, i.e. in the building, in the office, in the warehouse, in the store, etc., was pretty straightforward in terms of logistics. And it's similar these days, even now with the advent of sort of hybrid working. Those people who are in the business, if you like, are quite easy to consult with. However, the mistake that we often see is that employers don't consult or don't consult properly with employees who are absent from the business for whatever reason. And some examples of why people might be absent from the business are on the screen there. It could be any number of reasons, really, and I'm going to focus on some of those and some of the mistakes that we sometimes see. I suppose firstly, though, sometimes you get a question about whether we can actually make an employee redundant who is out of the business. The answer to that, of course, is yes. However, depending on the reason for that absence, there could be heightened risks around potential discrimination, as well as also the more general unfair dismissal risk for not consulting appropriately or fairly. So in terms of some of the ones that we were going to look at, firstly, ill health. It may be that it's a relatively short-term absence, but you still need to consult with that employee, which may involve them still coming to the meetings, even though they're signed off from their duties. They may be able to attend the meetings. It could be that it's having the meetings via Teams or Zoom or by telephone, and just ensuring that letters and emails are still sent to those people who are out of the business, even if it's short-term absence. But what about longer-term absence, where there's a possibility that the employee may be considered disabled under the Equality Act? Excuse me. Well, the usual principles around disability discrimination would apply, and I suppose the most relevant one of those is around the duty to make reasonable adjustments, especially depending on what the condition is. So you may have medical advice from a GP, from a consultant, from occupational health around, how to deal with certain meetings, how to deal with contact with the employee, and that's obviously going to be helpful. But in addition, you might want to consider other adjustments that you might want to make. If you step back, you've got an employee who is off on long-term sick, probably suffering from some kind of condition, probably not feeling that great about themselves in any event, and now they're faced with the potential for their role being made redundant. And so there will be a duty to make reasonable adjustments in those kind of scenarios, because it has to be dealt with sensitively and appropriately. So those adjustments might include some of those that I've already mentioned in terms of virtual meetings, but it could also include offering to have a meeting off-site, if you like, even in someone's home. I'm not necessarily suggesting you do that, unannounced, as it were, but clearly if that's something that is going to be in the employee's interest, given their condition, it could be something that can be accommodated. But there may also be other adjustments that could be sort of involved, including allowing the employee to be accompanied to meetings, which is not something you're obliged to allow. There's no obligation to allow an employee to be accompanied to a redundancy consultation meeting, but in these circumstances, it might be something that you do decide to allow. It might be that selection criteria, for example, either in relation to absence or attendance, or performance may need to be adjusted to more fairly reflect the impact that the absence has had on a particular employee. For example, if you were going to look at performance and the employee's been off for the last 6 months, do you look at a snapshot of time prior to that 6 months so that you get a more accurate indication of how the employee was performing at that time prior to suffering from the condition? So those are just some of the things to think about from an ill health perspective. The other area I wanted to touch on are those who are on family leave, such as maternity leave. A lot of businesses do get this right, but actually it's surprising how many we still see get this wrong. So lots of the same principles will apply. Invite the employees to meetings, even if they're virtual. As the slide says, keep them informed and actively involved. Make sure that the letters are going out to them. That's probably more important if you have people on family leave and they're not accessing their work email. Make sure that they're getting it in another way. But in addition, there are some additional rights around those who are on maternity, adoption, or shared parental leave, because they're entitled to be offered any suitable alternative vacancy ahead of anyone else that's at risk. So Carrie will look at alternative roles a little bit later, but it's a specific legislative provision where such employees have to be offered such a suitable role on no less favourable terms if it exists. You'll probably have seen that this right is due to be extended even further, certainly in the case of maternity, when an employee informs their employer of their pregnancy to 6 months after, from the date on which that they inform their employer of their pregnancy to up to 6 months after they return from maternity leave. So this will be coming in as law soon. We just don't know when at the moment and how it will apply to other family leave. Carrie.
Great. So the touching sort of leading on from what Richard was talking about, I wanted us to talk about discriminatory selection criteria, because this is often something that people worry about. So sometimes it will be unavoidable that one of the selection criteria that HR employers want to put in place could be indirectly discriminatory. It might be that it is looking at absence records, and it hasn't perhaps made adaptations for people who are on long-term absence. And that's a very difficult position to be in. The ideal position will always be that there's not going to be any direct discrimination in the criteria that's chosen, and that there also won't be indirect discrimination either. But what is important to remember is that in a situation where there is a piece of criteria that is indirectly discriminatory, and nothing deliberate, but something that is going to have that disproportionately negative effect on a group of people, that we are looking to see if there is an objective justification for that. That is essentially the defence to that assertion. So what is it? What is our sound business reason as to why it's important for us as a business to have that as a piece of criteria? So by way of example, there was a case involving Rolls-Royce where they used length of service as a criterion in their redundancy matrix. And that was seen to be indirectly discriminatory against younger workers because they wouldn't have built up the same length of service. But it was found to be justified. And that's because it was found and agreed by the tribunal that the objective justification for using length of service for this business was that it was there to reward loyalty and to help maintain a stable workforce. So where do we see this go wrong in practice? Well, it's often because people will rerun the same selection criteria and perhaps not have thought about whether it still fits the purpose at that stage in the business at that time. But also it might be that actually it's a bit sort of cart before the horse, and the criteria goes out and actually it's more of an afterthought as to what the business rationale might be if it's challenged as being an indirectly discriminatory piece of criteria. So it's just making sure that some thought's been given to that before the selection criteria goes out. It's helpful to remember that a tribunal is not going to substitute the selection criteria that a business has chosen. It's only going to interfere where that criteria is such that it would be a piece of criteria that no other reasonable employer would have used in the way that that particular employer used it. And sort of slightly away from this point about criteria, but one that often comes up time and time again for us, is that when you're scoring against your criteria, it is still really, really helpful, to the extent you've got manpower to do it, is to have two reviewers. So can you have two people looking at the scores and helping to remove that suggestion that there is bias from one particular line manager, for example? That's always really, really helpful for us to be able to show evidentially when you have a challenge. So I'll hand over to Richard.
Thank you. So roles. So imagine this. So the phone rings and a hypothetical client says to us, we want to make Dave redundant. And I say hypothetical client because I'm sure none of our clients would actually do this. But so we get a phone call saying we want to make Dave redundant. Carrie, what would be the first question that we would ask? How
long length of service?
Length of service, that would be a good one, because obviously the 2-year unfair dismissal rule, so excellent. And then we'd follow up and we'd ask, what's Dave's role? the reason for that is that it's the roles that become redundant, not the people. Of course, people fill those roles and they may end up being dismissed by reason of redundancy, but it's the role that becomes redundant, not the person. So I mentioned earlier that redundancy is a potentially fair reason for dismissal, unless you've got 2 years service, as identified by Carrie there. But it's also quite quirky compared to the others, as most of the others relate to the actual individual and not the role itself. So if, for example, you want to dismiss Dave because he's sworn at a customer, that's a conduct issue. If Dave's not performing properly, that's a capability issue in terms of performance. If Dave's been off sick for 12 months and there's no sign of him returning, that's another capability issue, in terms of his ill health. So those are all Dave-related issues, if you like. Poor Dave, he's got quite a few issues there. But if a role is no longer required, then that's not a Dave issue, that's a headcount issue. And it might just be that Dave is the person in that role. So if one of your managers says to you, we need to make Dave redundant, it's potentially not actually a redundancy scenario, because it seems that it might be a Dave-related issue and it might be one of the other potentially fair reasons for dismissal. So moving on from Dave in this, to sort of draw out from that example, as a reminder, a redundancy scenario can arise when there is, for example, a workplace closure, or quite often when there's a reduction in the number of employees required to fulfill a particular role. Excuse me. So that might be, for example, you've decided you don't need a reception area anymore, so you no longer need a receptionist. Or it could be that you've decided to reduce the number of people in a team, so you're moving from 10 sales executives to 6. So as you can see, that's all quite role related. And where we see people making mistakes are some of those examples that we set out on the slide. So in any redundancy situation or scenario, especially when it comes to headcount reduction, a really useful starting point would be any kind of organization chart. That's going to be a really useful starting point to identify who's in what roles. However, what we would say is you need to be wary of placing too much reliance on an org chart, because lots will depend on what the individual is actually doing on a day-to-day basis. It's not purely about the job title. So some job titles will be historic, for example. What's on someone's contract of employment when they joined you 15 years ago might not be what they're doing now. It's just the fact that the contract hasn't been updated. And it may not be representative of the role that they're carrying out today. So it's really important not to focus on what the role actually is, what the people in those roles are actually doing, rather than blindly relying upon an org chart. It's actually quite surprising how many times challenges are made by employees within a particular selection pool, pointing out that although we have the same job title, actually what we're doing is very, very different roles. And quite often when you dig deeper, there is some justification to those challenges. I always quite like giving examples that I can relate to. And so I'll refer to a senior associate in a law firm. Carrie's a senior associate and she specializes in employment law. We have other senior associates who specialize in property law or family law or commercial disputes. So they're all senior associates, they've all got the same job title, but they're all doing very, very different jobs. And that's the role element. So I guess that's the one thing that we would say in terms of a mistake to avoid. What we would say is the sort of reverse to that sometimes is that people doing very different jobs, as it says at the bottom there, or sorry, with different job titles, could have interchangeable skills and actually be carrying out similar work. So where that is the case, you have to be careful about and considering and ensuring that you consider what is the role that they're actually fulfilling, even if they do have slightly different job titles. So those are a few points there about ensuring that you focus on the role, because that's a mistake people often make by focusing on the person. Carrie.
Great. So our last mistake to avoid is really getting it wrong with alternative employment. So a dismissal is likely to be unfair if at the time of dismissal, so the date that someone goes, the employer has given no consideration to whether suitable alternative employment exists within its organisation. So one point that we see come up in challenge quite a lot is where perhaps a business hasn't considered the extent of the vacancies it might have across its wider group structure. Now, this is going to be more relevant to situations where HR have a permanence across the whole group structure. Perhaps there's a centralized HR function, or where the company in which the roles at risk of redundancy exist actually exerts the most influence over the group structure itself. And in those situations, what should be examined is where the vacancies arise not only in the company in which the role is at risk, but also in the wider group company. And we see the definition referred to in the legislation of an associated employer. So is there suitable alternative employment in an associated employer? So that still requires a bit of a judgment call, a bit of a question about what's reasonable for you to have to do as a company HR. But certainly it's just making sure that that has been considered, rather than just thinking it's very much a situation just for the company at which the role is at risk. What we also see come up as a bit of an issue is where it might be that certain roles that would have been attractive to the person that is at risk have been discounted, so haven't been put forward to them for their own consideration, or not enough information has been given about the vacancy for them to make an informed decision. So for example, they're just not allowed to know what the financial bracket will be on salary or benefits. So they're not really able to make an informed choice about whether that really would be a suitable alternative for them. So it's important not to be too ruthless about the information you provide or about the vacancies you provide as well. And also just remember that there is that great communication between companies, and it's very much everyone works together in a group to not exclude where those greater opportunities might arise from. And lastly, I think also what's probably helpful to remember is that the fairness of a redundancy dismissal is judged not only at the date at which you give the notice of dismissal, of termination, but it's when the employee's employment actually terminates. So the duty to look for a suitable alternative will continue even after you've issued the notice, in case something comes up in the notice period if it's being worked. So even then, is there something that can be done to try and save someone's continuity of employment, security of employment? So those are just some key points from Richard and I on mistakes to avoid, things that we see in practice. Some of them are more tricky, some of them are easier wins, but we hope that you found sort of our insights useful so that you can take those away. And thank you very much for joining us.